A few days ago, guys, I made a video to break down the new United States Customs and Immigration Services green card rule. The one that say if you're in America on a temporary visa and you wanted your green card, you must now leave the country and apply from the country you came from. That video got some reaction to stuff like that. And the most common question in the comment section is, how is this legal? Let's answer this question. Immigration lawyers across the country are now saying the same thing. Is this actually legal or is unconstitutional? So here's a video here. Legal challenges are formed from this right now. Immigration lawyers all over the country is calling this memo legally vulnerable on multiple fronts. And the one firm takeaway from this legal expert is that the United States Customs and Immigration Services cannot change the underlying law through a policy memo. The courts will have the final say in all of this, guys. But here's the catch, and this is what I want you to truly understand today. Even if the courts eventually block this rule, the damage to the people already in the middle of the green card process may have already happened and is already done. Because the United States Customs Immigration Services just changed the standard from do you qualify to are you worthy enough to be an American citizen and be in America. And that shift is already affecting real people right now in real time. That's the main question we're getting today. So today on the Whiskey Tango Foxtrot podcast, part 2 of the green card story, what the legal challenges look like, who is fighting back, and what the courts are likely to do, and what that means for you or somebody you know that might be affected but trying to get a green card for in the United States. So let's talk about it. So quick recap from what part 1. On May 22nd of 2026, United States Customs Immigration Services, the federal agency that handles immigration paperwork, issued a sweeping policy memo. The memo said that from now on, foreigners in the United States on temporary visas, student H-1B workers, spouses of citizens, refugees who want to apply for green card must leave the United States and apply from their home country instead of staying in the United States. So that happened on May 22nd. For more than over 50 years, people could complete the entire green card process without ever leaving America. That process is called adjustment of status, or AOS. That's what it's called. This memo effectively restricts that process to what the United States Customs Immigration Service called extraordinary circumstances without ever defining what extraordinary actual mean or defining it. Approximately up to 600,000 people apply for green cards inside the United States every year. All of them are immediately affected. So if you know somebody got loved ones here in the country waiting on the green card status, they're now affected. So how does this work? Now here's a critical update from that video. The memo has been out for less than a week, and the legal community is already calling it one of the most legally vulnerable immigration policies the Trump administration have ever issued. Here's why. So let's break this down. So the 3 core legal arguments that the immigration attorneys are already building around this case. These are the grounds on which the courts, and the case are more likely to act on. Legal argument 1, the United States Customs Immigration Services cannot change the law with a memo. That's a legal argument on 1. This is more fundamental challenge, and the one that legal experts are calling the strongest. The Immigration and Nationality Act, the federal law that governs immigration, gives the United States Customs Immigration Services discretion over adjustment of status. But discernment means the ability to weigh individual cases. It does not mean the ability to rewrite the standard entirely through an internal policy memo. The New York immigration attorney Cyrus Mahad have argued that the memo framing of adjustments as quoted as extraordinary relief appears nowhere in the Immigration and Nationality Act. Congress never used that language. Congress never said adjustment status were extraordinary. It builds in that the law as standard process. The legal firm Bond, let's put it plainly. United States Customs Immigration Services cannot change the undefined law through a policy memo. Legal challenges are epistolated, and the courts will always have the final say. So that's legal argument number one. Now, legal argument number two, the Administration Procedure Act violation. This one have teeth because courts have used the exact arguments to block the United States Customs Immigration Services memo before in the past. The Administrative Procedure Act, the APA, requires that when a federal agency wants to create a supplemental rule that change how the law works, it must go to a public notice and comment period. That means the agencies have to publish the proposed rule, give the public time to react, considering those response, and only then finalize the rule. United States Customs Immigration Service skip the entire process. This issue, this as an internal policy memo, not a formal rule. Immigration lawyers argue that is this direct violation of the APA because this memo does not just imitate existing law, it fundamentally change how hundreds of thousands of applicants will be judged. This is submitted rule change. A submitted rule change required notice and comments. Here's why that matters in particular law. Courts have used the exact argument to block the United States Customs Immigration Services memo before. In 2018, a federal judge issued a nationwide injunction blocking a United States Customs Immigration Service memo on unlawful presence, simply because they failed to follow the rule, the APA notice and comment requirements. That procedure is directly valid here. So that should be number one, more number two. But the third legal argument as well, this is number three, due process. What about pending cases? This is another third one. This is an argument that affects the most people right now. Right now, there are hundreds of thousands of people who are already filed for their green card application. That's I-485 before this memo was issued. They filed under the old rules. They paid the fees. They submitted the paperwork. They have been waiting sometimes for years. This memo does not clearly say whether it applies to those pending cases. And the ability is already creating chaos. Immigration law firms Reedy, Norman Brown put it starkly. The standard has shifted from does this person qualify or is this person worthy to be in America? And that shift is being applied retroactively to people who played by the old rules. Legal experts say court may find that applying this new standard to already filed cases raise serious due process concern, specifically reliable interest. People made life decisions, quitting jobs, selling property, keep their family here based on the old rules. Challenges go based on the old rule. Changing the standard mid-application without warning may violate their constitutional rights. They may not have they may have the full constitutional right, they have limited because if they're following the rules. The law firm summarizes directives. Law firm from federal courts may address whether the memo will actually applies to already filed cases to raise due process or relevant interest concerns. That's crazy. They didn't even say we have to go this far. So what does the government say in a defense? So what does the United States Customs Immigration Services say to defend the so-called memo change? Let's see. Now, in the legal defense for the United States Customs Immigration Services, and it's not nothing. Let's give it a straight thought here. Said this memo is not a new rule at all. They're saying it is the classification of existing law, a restatement of how adjustment of status was always supposed to work under the Immigration and Nationality Act. The United States Customs Immigration Services officially statement reads, "We're returning to the original intent of the law to assure aliens navigate our nation immigration system properly. From now on, an alien who is in the United States temporarily and wants a green card must return to their home country to apply, except in extraordinary circumstances." On the APA arguments, The United States Customs Immigration Services is expected to argue that because this is the interpretation memo rather than a new substantive rule, it is exempt from the notice and comment requirement under Section 5553BA of the APA. This is a legit legal distinction. Whether courts accept it will be the question. We'll see. On the scripted argument, the United States Customs Immigration Service will point to the phase and the scripted is the Immigration and Nationality Act. This statute does say the Secretary can exercise dismissal and granting adjustment of status. United States Customs Immigration Services will argue that broad descriptive languages support their ability to restrict how discreet and exercise they can push. And here's a wrinkle that immigration lawyers are gripping with. The Supreme Court in 2024 decided in the Loper Bright versus Ramirez elimination Chevron defenses, meaning courts no longer automatically defer to a federal agency in protection of obedience status. Courts now have to find the best reading of the law themselves. That cuts both ways. It could work against United States Customs Immigration Services if courts read the status differently, but also mean courts have more freedom to read in the favor of the government if there's up the government reading here. So it can go both ways on this. So this is why it's important to keep up y'all update on this. So what happened in court? The likely time frame. So what does the court fight actually look like from here? And walk you through this, how it typically works. Step one, the lawsuits are getting filed immediately. Immigration advocates organizations and law and legal groups are already prepared to file it. Except the first lawsuit to be filed within days and already done by now. If it's not been filed already by the time you watch this video, probably have. The plaintiff will almost certainly include immigration directly harmed by the memo, immigration advocate groups, and potential states with large immigration populations. The California, New York, or the Democratic blue Minneapolis, where saturated cities and states and stuff. Oh yeah, everybody filing lawsuits. Step two, the motion for temporary restraining orders. The fastest legal tool available to challenge is a temporary restraining order, a TRO. This act the judge immediately paused the memo while the legal challenge worked through the courts. The judge can grant a TRO within days of the lawsuit being filed. If granted, the memo will block from taking effect while this case continues. This is not a guarantee though, but courts have granted TROs against the United States Customs Immigration Services memos in the past. The 2018 unlawful present memo would block this way. The legal arguments here are similar enough that many immigration attorneys believe a TRO is a real possibility. Step three, preliminary injunction hearings. After the TRO, the courts will hold a hearing for preliminary injunction hearings, a long-term pause. Why? The full court is litigated. This is where the APA argument and the due process argument get their first full airing. This typically happens within weeks or months. So that's going to be soon coming up here. Step four, appeals. Of course, whatever the district court decide, respect an immediate appeal either side. Yes, you will respect that 100%. Either by the government if blocked or by the challengers if not. This case will almost certainly end up in the district court level and possibly this will go up to the Supreme Court. And this will be months, if not weeks. This will be years. Before we get anything back, I can believe this will take a couple years before we get a complete saying. We'll probably have a new president by the time this could get all unwrapped or shit. The full timeline could be months to years to a final resolution, but the most important thing, the restraining orders and the preliminary injunction decisions will come in weeks and days. Those are going to be first, and whatever comes from this will be appeals. This will go up to the circuit court. This will go up to the Supreme Court. This will be a years on year get a final say. What does it mean to be pending application? I want to speak directly to anybody watching this that have a pending green card or who wants to file one, because this is a real issue. Do not leave the United States. Leaving could interrupt and briefly, and your application could trigger a bar to you not even coming back to the United States. Because Trump have a lot of countries that bar from people coming into the United States. So right now, if you're trying to plan on applying for a green card, you haven't done so already, do not leave the United States. Do not withdraw a pending I-485. You already filed your green card application before May 22nd. Do not pull it at any means. This memo does not clearly say pending cases are grandfathered, but withdrawing could waive protection you might still have. Hold it where it's at. Do not file a new I-485 without legal advice. If you were about to file, pause under the new policy, a new application subject to extraordinary circumstances standard. Whether it makes sense to file anyway or wait for a court ruling depends entirely on your specific situation. Talk to an immigration lawyer as soon as possible. And I've had a legal advice. I'm not a filing it back. Talk to a lawyer. Get real legal advice about that. All I can say, if you have application in, wait, don't pull it. If you haven't filed yet, talk to an immediate immigration lawyer to get the full day-to-day, up-to-minute take to what to do. The bigger picture here, I want to zoom out. Since January 2026, the Trump administration has issued a travel ban on 75 countries that put all immigration visas positive for donation. It has restricted SBA small business loan to green card holders. It acts as Supreme Court extend the government power to revoke green card at the border, a case that was argued in April and still pending ruling. And now this memo would effectively tell hundreds of thousands of people already living legally in the United States that the path they were on may no longer exist. Legal immigration in America is being reshaped from multiple directions simultaneously. Courts have blocked some of the policies, others have moved forward. The pattern is clear. The administration telling the legal limits of executive powers over immigration, and the courts are where those limits get defined. What happened to almost 600,000 people who apply for green card in the United States every year? It matters for what kind of country America decides to be the question of legal immigration, and who gets to make that decision, the executive branch or Congress and the courts. It should all be Congress and the court, but hey, we do what we got to do here. So here's the bottom line. United States Customs Immigration Services green card memo is less than a week old and has already faced serious legal challenges on 3 fronts. The Extraditional Authority argument, the Administrative Process Act, and due process for people with an pending application. Legal experts say courts will have the final say. And based on how the courts handle simulation, this memo in the past, a legal block is a real possibility, but it's not a guarantee. And until court actions, the memo is in effect. If you have a pending application, do not make any sudden move. Get full legal advice. Do not leave the country. Do not withdraw your application. I'm keep covering this story as much as I can. The lawsuits, the temporary restraining orders, the procedural injunction hearings, every major development, get a new video, every update that come, major update that come. Drop a comment, like, if you want somebody going through them, let me know if you got somebody going to the green card process right now. Share the video out. Let your friend and family know what's going on. I'll try to keep you informed as I can. Any news come out, like, comment, subscribe, guys. Share the video. I appreciate you being here. Any new update come, I'm out. The next one. Peace.